Well, hello everyone, and thank you so much for joining me. I'm Lior Samfiru, the employment lawyer, and you've stumbled upon your live employment law session. Again, thank you for being here. Thank you for joining me. Lior Samfiru, that's me. I'm one of the founding partners of Samfiru Tumarkin LLP. Our firm, we practice employment law, and you can come across us in Ontario, BC, and Alberta. And if you're in one of those provinces, we're here to help you. We're here to answer your questions. And on this session, this is your perfect opportunity to inform yourself, to learn about employment law, to ask questions about the issues that you're facing. Maybe you're dealing with a difficult boss and you want to know how to respond. Should you respond? If what they're doing is legal. Maybe your job is changing, your hours are changing, your pay, your schedule, your shifts, what to do, what to say, what are the rights, ask. Of course, like so many people recently, if you've lost your job or you put on a temporary layoff, guess what? You're owed a lot more than what you realize. And I do mean a lot more. And it can start right now by asking a question and understanding what your rights are. This is your opportunity to get information, your opportunity to learn about employment law and have those issues resolved. So don't be bashful. This is no time to be concerned, to be shy. Just ask the question. I will see it, I will read it, and I will answer it. Now, before we start answering some questions, I want to give you some other contact information. If you want to connect with me and my team beyond just these 30 minutes that I'm here, so easy to do. All you do is you go to employmentlawyer.ca. Address is right there, employmentlawyer.ca. And when you go to employmentlawyer.ca, you can have a phone number there. You can call. There's an email address there. You can send an email. You can send a fax. You can fill out a form. It's right there for you. And of course, you can also learn a lot more about employment law, at employmentlawyer.ca. It's your one-stop shop for anything and everything employment law. I see questions coming in. I'm going to get to answering them. Reminder, you've just joined me, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, on this, my live stream session. Usually I'm not here on Fridays. Usually I kind of only do on Wednesdays here. I'm here today on Friday. I want to get a lot of questions answered. Had lots and lots and lots and lots of questions a couple of days ago. I want even more questions right now. Keep me busy, keep me on my toes, and let's get answering some questions about employment law. All right, first question of the day comes to us from Trevor. Trevor says, I know labor standards require employees to give 2 weeks notice of resignations. That's not true. What repercussions can your employer actually the employee actually face? How would an employer practically go about getting that enforced? So no, there's actually in employment standards, there's no requirement to give any amount of notice of resignation. Our courts over the years have decided that an employee that resigns has to give a reasonable amount of notice. Whatever reasonable is depends in every situation. So depending on the position that you're in, if you're in a very senior position, unique position that maybe is going to be difficult to replace, you need to give more notice. If you're working part-time in a minimum wage job that's probably going to be replaced fairly quickly, that's going to be a lot less notice. So really, it's a question of what is reasonable in your situation. Now, another place that can give us the answer as to how long you have to give by way of notice of resignation is your employment agreement. Your employment agreement may say that if you resign, you have to give us 2, 3, 4, whatever it is, weeks of notice of resignation. And if your employment agreement stipulates an amount of notice, that is the amount of notice that you should give. Now, you're right. As a practical matter, it may be difficult for an employer to enforce and to take legal action against an employee that has not given enough notice, but it is possible. If an employer can show that they've lost money, they've incurred damages because the employee did not give enough notice, they can take legal action against that employee. So something to consider, but no, there's no labor standard that outlines that. It's very different. Hopefully that makes sense, Trevor. If you have any follow-up questions, ask it right now. I'm still here. Same with you. See how easy it is? Trevor had a question, asked the question, I answered it. Now he knows. You can do the exact same thing, and I want you to do the exact same thing. Ask your question right now. If you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, And what I just did and what I'm going to do right now is answer questions on this live stream session about employment law. But I want your question as well. As you're listening, type in your question. All right, let's see. Our second question of the day comes from Pajit. I signed a non-compete agreement when I started my job in 2019, and I've had an offer from a competitor. I'm in Ontario. I know non-competes are not allowed after the 2021 law change, but was wondering what this would mean for one that predates 2021. I'm not an executive. So the reality is it's very, very likely not enforceable. Okay, very likely not enforceable. But that's not enough. That's not the end of the analysis. And here's what I mean by that. It's not enforceable, but that doesn't mean that your current employer, former employer, won't try to enforce it. Now, they will lose if they do that, but oftentimes employers do that because they want to send a message, and that means they will take legal action against you. All right, and you will have to litigate, and it can be very costly, expensive, and kind of brutal. You will win eventually, but you're still going to have to go through that process potentially if they choose to take legal action against you. So when it comes to non-compete, to say, oh, it's just not enforceable, so I can do whatever I want, not good enough. Okay, I would do the smart thing, the right thing. Talk to your employer. Tell them, listen, employer, I am going to go work somewhere else. I'm not going to go after your customers. I'm not going to release your trade secrets. I'm not going to hurt you in any way. And have that conversation with them. Just ignoring a non-compete, not a good thing. It could be very risky. For the vast majority of people, they're not legally enforceable. But that doesn't mean your employer may try actually to enforce it. Okay, hopefully that makes sense, Pajit. I hope you understand what I mean, but here to answer follow-up questions if you have. By the way, if you've just joined us, just like Pajit, just like Trevor, you have a question about employment law, ask it. I see a question just came in. I'm going to answer it as well, but I want all of the questions today. I want lots and lots of questions. I want you to keep me busy. When I turn off my computer and at the end of the session, I want to be exhausted because I've answered so many questions. So please ask them. Again, I'm Lior Samfiru. And let's continue answering questions. Azadi, sorry if I mispronounce. In BC, can we still negotiate the severance even if the contract states you agree to accept the severance pay required under the ESA as full payment? Yes, you can. Now, in some cases, the employment agreement may limit your entitlements. I would have to review the agreement. I would have to review a few other factors. In probably 75, 80% of cases, even if you have that employment agreement, yes, we can still get around it and get you your full severance. But obviously, I want to see the agreement. I need to ask some questions, etc. But very important, just because you signed an employment agreement that tries to limit your entitlements does not mean that it's actually able to do so. And you could be entitled to significantly greater amounts of what's in your employment agreement, but we need to review that agreement and how to get around it. So, Azadi, the smartest thing, really the only thing you need to do right now is let's connect. If you lost your job, if you lose your job, let's connect. You can reach me through employmentlawyer.ca. You see that address on the screen right now, employmentlawyer.ca. We'll schedule a time to speak. We'll go over it, and we'll make sure you get everything that you are owed. Okay, and this is true for anyone, not just in BC. In Ontario, in Alberta, if you have an employment agreement and you're looking at it and say, man, I think this agreement gives away my rights or limits me, it might not. In fact, there's a really good chance that it doesn't. That's why we need to speak. Again, employmentlawyer.ca to connect with me and my team, and happy to chat about that. All right. Fantastic questions so far today. Excellent questions. A few more have just come in. I'm going to answer them right now, but don't wait, okay? Don't want to wait till the end of the session. Right now, you've got time. I have time. We can have a proper discussion. We're not rushed. So don't wait till the end of the session when I'm about to end and then ask me a question because I may not get to it at that point. Now I will. Now you can get an answer. Again, if you want to know about employment law, workplace rights, your job, your compensation, your wrongful dismissal, you name it, ask a question with me, Lior Samfiru, the employment lawyer. All right. Next question right now comes to us from Jude. Jude is joining us on Facebook. Why have we been blocked by government and not receiving my husband's CPP tax papers when it's always, I can't answer that. You'd have to speak to an accountant. or call the government. I really can't say why the government did anything in your husband's situation. Okay, let's see. Jesse, Jared. Jared, you've typed in like 5 different things. Let's see if I can get to it. My employer has sent me a letter this morning to change my employment agreement. This letter is to confirm that the amendment to your original employment agreement. Okay. Okay, so what your employer is trying to do, Jared, is to put in a term in your employment agreement that limits your future severance. So the problem with that is that potentially, if you sign that agreement can mean that you limit your severance significantly. It could literally cost you tens of thousands of dollars. It could even be more than that. It could be potentially hundreds of thousands of dollars. So best advice I'm going to give you, don't sign it. Certainly do not sign it without sending me a copy and letting me see it. But there's only one reason. If you're already working, that your employer wants you to sign a new employment agreement, and that is to take away rights you would otherwise have, right? If they wanted to give you rights, they wouldn't need you to sign anything. They would just give you rights. So the only reason you have a new employment agreement is to take away rights. And what they're trying to do with this agreement is to limit future severance. So if you sign this and a month later you're let go, you could be looking at a fraction of what you're actually owed. So do the right thing, do the smart thing. And this is not just for Jared, this is for everyone. Be very, very concerned if all of a sudden your employer introduces a new employment agreement. Okay, be very concerned. It's not a casual thing. Even if you look at it and, oh, well, salary is the same, the benefits are the same, the vacation is the same. Well, wait a second. If it was all the same, they wouldn't bother. There are potentially terms that will be significantly costly and problematic, just like here with Jared. So be smart, be concerned about these agreements. Don't sign them without me seeing them first. Of course, to reach me when we're not here on live stream, very, very easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. I want more questions. I see another question. I'm going to get to it. Before I get to continue to the rest of the questions, I want to give you another tool that you absolutely need to have in your arsenal, and that is the severance calculator. You can find the severance calculator at pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. One of the tools there you can click on is the severance calculator. What does it do? Well, I think the name says it all. It calculates and tells you how much severance you are owed. Completely free, completely anonymous. There's absolutely no way to pay for it if you wanted to pay for it. It's just there for you to help you to understand what you are owed. People are shocked when they use it. People think, oh, I lost my job. I get 3 weeks, 2 weeks, 4 weeks. All of that is wrong. You're probably owed a heck of a lot more than what you believe, what you think, certainly more than what your employer is offering. That's why we have the severance calculator. Go to pocketemploymentlawyer.ca. If you just lost your job and you're trying to figure out what you're owed, it's there for you, easy to use. If you think maybe it's coming up, tariffs are happening, maybe I'm going to lose my job because of that, you have to be prepared with this knowledge. Use the severance calculator. Or maybe everything's okay, but you're curious. You just want to know, hey, what would I be owed in a hypothetical situation when they let me go? Again, pocketemploymentlawyer.ca. Click on the severance calculator. Use it. Over 2 million people have. Check it out, free and anonymous. All right, let's see. Questions are what we're all about here. So I'm going to continue answering questions, and I want yours too. JD has our next question. My mother-in-law, who's 65 plus, was terminated with cause from a large nonprofit corporation for poor performance. She had been employed 14 years. She had planned on retiring in 5 months. She was previously written up for poor performance in January 2025. No previous disciplinary action. They included a 3-month severance if she signs a non-disclosure. It seems strange to offer severance for a termination for cause. What should she be doing? I'm surprised you're asking what you should be doing, because if you're talking to me, you probably know what you should be doing, and that is she needs to call me. Okay, and that's really the only thing she needs to do. She needs to call me so I can help her get what she's owed. Let's be extremely clear here. It's extremely difficult to fire someone for cause. Extremely difficult. Your mother would have had to do something pretty terrible, awful. Even if her performance wasn't great, that does not mean they can let her go for cause. Okay? So there's no way that this would be cause. No chance. Unless she stole, unless she hit somebody, unless she committed fraud, it's not cause. That means they have to pay her full severance. For her, that could easily be, I don't know, 18 months pay. 18. They're offering her 3. So unless my math is wrong, she's owed 6 times more than what they've offered her. Nonsense. She cannot accept that. Okay, this is a wrongful dismissal. A wrongful dismissal simply is a situation when you're let go and you're not paid your proper full severance. She was offered 3 months. She's owed probably 18. You get the idea. The math is pretty simple. She needs to give me a call. Okay, not unusual to see this. I want to remind everyone, for you, JD, your mother, everyone else watching, just because the company says it is terminating employment for cause doesn't mean that they're able to do so legally. In the vast majority of cases, it's not legal. They owe full severance. It's not a for cause termination. So you know what to do. Have her call me. I'll help her make sure she gets her severance, that she gets a proper record of employment as well, so she could get EI. We'll take care of it. She can connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's continue answering questions. I want your questions too. We still have time. You still have time to get your questions asked and sit back and let me answer it. So why don't you take advantage of that? Get the questions asked, and I will answer it, of course. Make sure that you have all the information before we end the session today. Just like Priya. Priya has the next question. Priya says, what does it mean employer change its term to terminate your employment at any time to may terminate your employment? I'm not sure what you're asking, Priya. An employer is allowed to let you go at any time as long as severance is paid. So it's not a question of is your employer allowed to let you go, because your employer is allowed to let you go. It's not a question of when can your employer let you go. It's a question of severance. In most cases, your employer is allowed to let you go, but they have to pay full severance. The problem is that in over 90% of the cases, 90% of the time, whatever severance your employer is offering or paying is a lot less than what they should be paying in 90% of cases. So if I'm going to look at 9 or 10 people here that have been let go, 9 of those 10 are going to be offered really bad offers. The 10th one will probably be okay, not great, but okay. 9 of them are going to be underpaid. So really, when it comes to losing your job, Priya, it's not about may, will, could. It's if you're let go. It's not about why, it's not about how, it's about the severance, okay? That's why you call me, or that's why you use the severance calculator, which we've talked about. Always do that. Never, ever, ever accept that offer. Once you accept that offer, there's no going back. There's no changing your mind. If you do, sign it. There's nothing I can do to help you. Okay, hopefully that makes sense. Priya, if I misunderstood something, or if you have a follow-up, you have time, ask the question right now, and I'll be more than happy to talk. All right, let's see. Azadi has a follow-up question. Azadi asks, let's see. I'm in a small industry. If I involve a lawyer in my severance negotiations, could that impact my future job prospects with other companies? Do employers typically share information about applicants? I'll say this to you. I've been doing this for 23 years. I have never had anyone tell me ever in 23 years, thousands of people, that because I got involved, it hurt their job. Number one, it happens often. Number two, one of the things that we negotiate when we negotiate severance is positive letter of reference, a positive verbal reference. It's not going to happen. It's not an issue, okay? And keep in mind, if you're involving a lawyer to try to do something sneaky or bad, that's one thing. But if all you're trying to do is get what you're legally owed, how can that ever be held against you? You wouldn't need me if your employer was acting legally. So what are they going to tell someone else? Hey, I was acting illegally? No. So it's not going to happen. It's not an issue. Don't be afraid of the process. In almost every case, we're able to resolve matters quickly, on good terms, and without major conflict with your former employer. Okay? So always, if you lost your job, let's talk about it. Don't be afraid of the process. We'll make sure you get what you're owed. All right? Don't be afraid of that. Thank you. That's a very important question, though, Zadie, because people, I think, are wondering that. If you've just joined this session and you're looking around wondering, well, what is this? Well, first of all, welcome. I'm glad you're here. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm here taking questions, your live questions about employment law, about workplace rights, about wrongful dismissal, constructive dismissal, temporary layoff, harassment, bullying, human rights. I think you get the idea. This is your opportunity to ask a question, to get some help, to make sure that you know your rights. It's not really helpful to have rights if you don't know what they are. Well, on this session, we make sure you know what they are. We even out the playing field so that you have the power. So again, I'm Lior Samfiru, the employment lawyer. Let's continue answering questions. And by the way, you still have time, so please, please, please bring it on. On YouTube is our next question. This is from, I don't know how to pronounce that. Antims. Okay, I think it's Antims. I'm a manager that works in a specialized position. If I ever take a sick days, it's because there's nobody trained to cover. Oh, sorry, it's impossible to take a sick day because there's nobody trained to cover my position. We do have two positions. Both have been vacant for a long time. My boss, and these positions are tailored to support mine and or cover during absences or where I'm on a holiday. My boss caught wind I'll be submitting notice to take parental leave for 5 weeks, and I found out through the grapevine he will not be able to approve it. Is my boss allowed to deny parental leave? No, it has nothing to do with your boss. He can't approve it any more than he can approve your wife being pregnant. It's nonsense, of course. No, you have a right to take parental leave. You, in fact, could be off work for many months, and doesn't matter what the company wants. Doesn't matter what issues it causes them. When you take parental leave, you're not asking for permission. You're telling your employer, "I'm taking parental leave. This is when I start, and this is when I expect to be back." If you know, that's it. By the way, same with sick days. You don't need permission to take a sick day. You may need a doctor's note, but you don't. If you're sick and you can't work and you have support, your employer can't say too bad. It doesn't work that way. When it comes to sick days, again, it's not about a permission. It's about notifying your employer. Vacation is different. Vacation, you do need the permission. But sick days, parental leave, disability leave, absolutely not. You're telling your employer. They have no say in that. If your employer gives you a hard time, if they do anything to you, man, call me. That could be potentially a human rights violation, an employment standards violation, illegal, doesn't make sense. They'll never do it. All right? So you know what to do. You can reach me through employmentlawyer.ca. You can do that now, and I'd be happy to help you and make sure that your employer is not doing anything illegal. All right. Okay, so let's see. Continuing with some questions here. Again, with me, Lior Samfiru, the employment lawyer. Joey has our next question. I am off on WCB Alberta. I got approved for PTSD and depression. However, my moral injury was deemed non-compensable. I was discriminated against for being gay. Can I sue and keep my WCB benefits? So if you can show that your employer discriminated against you, that's a human rights violation. You can commence a human rights action as well, potentially. That could also potentially be a constructive dismissal. And if you can show that you were mistreated, whether it's because you're gay or frankly for any reason, that may mean that you can consider your employment as terminated and get your full severance. The problem, of course, Joey, in these situations is proving it. I'm sure you'll agree with me that your employer is not going to admit it. They're not going to say, yes, we discriminated, we mistreated Joey, right? They're not going to admit it. They're going to deny it. Oh my God, never happened. We were great. So the question is, how do we prove it? If it's just your word against theirs, that may not be enough. So is there a witness that's willing to speak? Is there anything in writing? Is there a recording? Is there notes that were taken contemporaneously? So those are some of the things we may be looking for. Whenever we're dealing with these issues, it's something you have to understand that they're going to lie. They're going to deny it. So how do we prove it? Because you are the one that would have to prove it. So how do you prove it? But if you can show that you were discriminated against, yes. Can you take legal action? Absolutely. If you have the proof, let's connect. Connect with me through employmentlawyer.ca, and let's talk about how we proceed with that so you don't let anyone get away with something illegal. That's not right. So again, employmentlawyer.ca to connect with me. Oh man, lots of questions today. I love it. We're getting close to the end of the session, but you still have time. I promise you, if you ask a question right now, I will not end this session without answering. Okay? So why don't we make sure you do that so that you don't regret it over the weekend? Man, I wish I would have asked Lior this question. Just ask it. I'm here. Next question is from People 1990. My husband has been with the same company for 5 years. It's gone through 3 ownership changes, and each time they've kept him on. Today, out of nowhere, the one owner fired him because he's not performing to his standards for what he's paid. It's been about 8-ish months since they took over. Is this legal? Well, yes, it is legal to let him go. Remember what I said earlier, your employer is allowed to let you go pretty much for any reason as long as severance is paid. The question is, did they pay him proper severance? The fact that they may not be happy with his performance does not mean that they can avoid paying him his full severance. Now, remember, over the years that he's been with them, every time the ownership changed, his seniority carried through. All right. So he's now a 5+ year employee, and he has to get paid severance as a 5-year employee. Again, I don't know your husband's age, and I don't know the job that he was doing, so I can't give you an accurate assessment, but it's easily probably going to be 6 months. And again, depending on his age and position, it could be much more than 6 months. So that's what he's owed. If they pay him proper severance, there's nothing illegal about it. If they paid him no severance or not enough severance, this would be what we call a wrongful dismissal. So can they let him go? Yes, they can, but they have to pay him his full severance. That's what's at issue here. So what I would do, People 1990, is have your husband call us ASAP. You can reach me and my team through employmentlawyer.ca. Again, employmentlawyer.ca, and I'll make sure that he gets the help that he needs. All right, let's take one more question on this session with me, Lior Samfiru, the employment lawyer, and this question comes to us from Ben. Ben says, this morning I found out I was let go from my organization. It is one of the largest in North America and was downsizing at the beginning of the fiscal year. I would have been there for 3 years in June. They offered me 3 weeks severance or 7 weeks enhanced should I sign their letter. Any way to negotiate a higher amount? I am in a niche industry and job prospects are not looking great at the moment. Well, I hope you've been listening, because all I've been talking about on this session is that you have to negotiate, and that's what we do. Someone in your situation, again, I don't know your age, but you could easily be owed 6 months of severance, maybe even more. You say you're in a specialized industry and they've offered you 7 weeks. Big difference. 6 months, 26 weeks, right? And 7 weeks is a heck of a lot less. So easy. Usually once they hear from me, they get a letter from me, don't tell anyone, just between us, but in that letter, I'll probably ask for 9 months. They'll come back and say 4, and I'll say, okay, 8, and get it resolved for the 6 months that you're actually owed. And that's that. That's how simple it is in most of these cases. So Ben, you got to call me, okay? You got to reach out to me. Phone number, email address, you can find that very easily at employmentlawyer.ca. Again, employmentlawyer.ca. That's the time we have for today. But before I go, I want to remind you that just because I'm turning off my webcam here and closing the live stream doesn't mean I'm going anywhere. Doesn't mean my team is going anywhere. We're still here for you. You can still reach out to me and my team easily through employmentlawyer.ca. Phone numbers there, email address is there, all the contact information is there, so we can have a private discussion, a private email exchange. Take advantage of that, okay? Let's make sure you don't walk away from rights that you have. Thank you so much for joining me. Really appreciate it. Great to be here and answer questions. I'll be back next week, so will my team, but don't wait. Go to employmentlawyer.ca in the meantime. I'm Lior Samfiru with Samfiru Tumarkin LLP. Thank you, everyone. Have a great weekend. Bye.